Hello, and welcome to the channel. We are a website devoted to the spiritual practice of Buddhist Shaolin, Wudang Tai Chi, and Taoist Yoga, having studied under the greatest masters of the 20th century. We are devoted to the philosophies and development of the body, the mind, and the spirit, with graduate studies in divinity, molecular biology, psychology, and philosophy at the University of Chicago. We are also devoted to the preservation of our environment and the promotion of public health, safety, and welfare, with master's degree in legal studies and national awards as champion of the public interest for our work with the Environmental Law and Policy Center. You can find documentation pertaining to corruption here in Lockport, Illinois, at our website under the section called the Lockport Files. Please visit our channel for all of your questions regarding spirituality, the environment, corruption, taxes, and the promotion of urban sprawl development. Thank you. This documentary is going to evidence the extent of organized crime at the highest levels of government here in Illinois and Will County. This is going to look at the corruption involved in the construction and planning of the I-355 Tollway in Will County, Illinois. And the story goes back to the late 60s, when the federal government adopted the Federal Uniform Relocation and Real Properties Acquisitions Act. One of these acts was designed to protect the environment, and the other was designed to protect the public. It was in the same year that Congress also enacted RICO legislation. That is the Racketeering, Influencing, and Corrupt Organization Statute, which recognized how organized crime was infiltrating into legitimate business interests, and the statute gave the government the power to prosecute those organized crime activities that were taking place within legitimate business or government activities. 1970 was an important year in Illinois because that was the year that a brand new constitution was adopted for the state. And this was done at a time when corruption by organized crime in Cook County was at the highest levels, involving the courts and law enforcement as well as the legislature. It was in 1970 that the Secretary of State, Paul Powell, passed away, and $750,000 in cash was discovered in his Springfield apartment. Paul Powell was a very corrupt government official who had a long career in government in Illinois in the Senate, as well as being the Secretary of State. He was also well connected with the gaming industry and racetracks here in Illinois. When the new Constitution was adopted, one of the corrupt government officials became the first head of the Illinois Department of Transportation. That was the corrupt lobbyist William Cellini, who was later prosecuted for corruption. He used his influence in transportation to become the head of the Asphalt Paving Association of Illinois and their main lobbyist. It was in 1968 that the Illinois State Toll Highway Authority was permanently created, negating the prior promise that after the tollways were constructed, they would become freeways. The corruption involved with the construction of I-355 in Will County goes back to the early days of the 60s and the 70s, when this project was first being planned and then had to be canceled because of the requirements of the newly adopted environmental and relocation laws in 1970. But that did not stop IDOT from acquiring properties for this project, establishing a location for connected developers decades before having to submit to environmental studies and public hearings for federal project approvals to construct this project. This history of corruption involved sweetheart deals for the connected developers who received advanced information about locations for interchanges, making those properties incredibly valuable for commercial development, This was orchestrated through the Office of the Attorney General of Illinois. The new Constitution that was adopted in 1970 created a special division of the Attorney General's office called the Executive Council. This was an appointment made by the Attorney General for each and every agency of Illinois government. It provided a politically connected attorney in charge of the legal affairs of that agency and the individuals that ran the agency. In any legal action involving the agency, those political appointments of executive councils were given the authority to direct the Office of the Attorney General in any judicial proceeding. They called the shots, and these were political appointments which were involved in payback schemes with connected law firms and connected developers who paid campaign contributions in return for advanced knowledge of highway interchange locations decades before environmental studies and public hearings. This was decades before the project was ever given federal project approvals. This scheme also involved corrupt politicians, public officials, judges, and the courts. Under this Office of Executive Counsel, the Attorney General's office was no longer the attorney for the people of the state of Illinois. They were now the attorney for corrupt public officials using their authority in state agencies in the practice of pay-to-play, with the Attorney General getting a sizable portion of the campaign contributions. This investigative series, called Profiles in Evil, is devoted to the exposure of organized crime and RICO violations at the highest levels of government and industry. It starts in Series 1 with the history of Al Capone and the machine politics of Cook County, focusing on the infamous First Ward and the growth and influence of the Jewish mob of Maxwell Street, Jewtown, in partnership with the Italian mob of Taylor Street, Little Italy. It will expose the involvement of mob bosses and Maxwell Street in the assassination of JFK and the cover-up with Maxwell Street's Jacob Rubenstein, aka Jack Ruby. The second of the series and this current program will expose the massive fraud and corruption involving the planning, approvals, and construction of I-355 in Will County, Illinois. It will evidence the mob's control of government and the courts in order to further the interests of casino gambling in Illinois. The Empress Casino Group, based out of Las Vegas, used the Attorney General's office and corrupted courts in a scheme to enrich connected developers and law firms in secret land deals. This practice encouraged the growth of urban sprawl, generating enormous profits for connected politicians, developers, contractors, and law firms. This has caused the highest taxation rates in the nation for the people of Illinois. The third of the series will expose the massive public health violations and fraud concerning the Lockport, Illinois sanitary sewer system. The enormous cost of infrastructure development and record high taxation has caused the corrupt politicians to cover up the failure and destruction of the city's old sanitary sewer system as they continue to build new roads and strip malls as part of their urban sprawl agenda using connected contractors, generating over $500 million of annual revenue for the Austin-Tyler road building contractor, subsidized by taxes and federal grants. This failure involving public health, safety, and welfare is even more insidious than the corruption involving the Flint, Michigan case. The fourth of the series will expose the corruption involving Merrill Lynch Bank in Oak Brook, Illinois, and the D'Alese crime family's participation in a nationwide scheme involving the dental implant industry. This scheme involved money laundering to the tune of $10 million a year for over 20 years. This scheme also involves massive corruption in the courts covering up the crimes and preventing and interfering with criminal investigations. This series will evidence how organized crime infiltrated the major banks and the Federal Reserve. Warren Buffett's Berkshire Hathaway owns U.S. Bank, which owns Merrill Lynch Bank, which owns BlackRock, which owns Prologis, and Berkshire Hathaway is partners with the billionaire Pritzker family and the current governor of Illinois, J.B. Pritzker. The fifth of the series will expose the corruption of the Bush crime family and their influence with the FDIC that caused the bank failure of a Chicago-based Indian-owned financial institution and the takeover by an Arab-owned bank from Texas created by the Bush family that was being used to generate millions of dollars of funds to Afghanistan. The purpose of this action was to cause a $35 million default for an Indian business that was developing the world's first viable thorium-based nuclear reactor. The military-industrial complex did not want an affordable, safe energy source that could never be used for making nuclear weapons and would end the world's dependence on oil. This will further evidence how organized crime and the Bush crime family were involved in the JFK assassination and the control of the Federal Reserve and the FDIC. Section 1.05-6 of IDOT's Policies and Procedures Manual clearly explains the legal requirements for any acquisition of property for the construction of a highway. The manual references the state statute at 605 ILCS 5/4-510, which clearly details the legal requirements for any acquisition of property. The acquisition can only occur after environmental studies and public hearings. It also requires the recording of a map with the county recorder's office and official notices to all property owners of record affected by the map. Under federal laws, it is clearly understood that the environmental studies and the public hearings are part of the official process to determine whether or not the highway should be built, and in those environmental studies, it requires the production of an environmental impact statement, an EIS, for the federal project approvals. Those approvals can only be given after the public has participated in the decision-making process. The environmental impact statement submitted for federal project approvals brazenly lists 27 properties acquired for this project between the years of 1970 and 1994 prior to the environmental studies and public hearings as required by state and federal law. Two properties of note are property 1X20109, which was the property of this complainant, John Walliser, and property parcel 1X20112, which was acquired by the Tollway in a condemnation hearing case number 91ED15060. The property list clearly shows that this acquisition was in violation of several state and federal laws. And the condemnation complaint that was filed in the Tollway condemnation complaint is a matter of perjury and forgery. My parcel was acquired by IDOT under a federal regulation known as hardship acquisition, which can only be made after the environmental studies and public hearings. However, the acquisition of the hedge property by the Tollway was made in an action under eminent domain originally filed by IDOT. The court filings show that this complaint was against a connected developer, the very same legal entity who sold the property for the Tollway headquarters in Downers Grove, going by the name of Continental Offices, one of the largest real estate investment trusts in Illinois at that time, along with the connected developer Donald Hedge, who is a friend of the Tollway board member Roger Clark and the Senate Minority Leader Pate Phillip. Pate's brother Art was a Tollway Board member and later chairman of the Tollway Board. The complaint filed in 1991 clearly states that IDOT and the state of Illinois, pursuant to several state statutes, has selected, approved, designated, and authorized the construction of Federal Aid Project 340 in Will County, Illinois. This complaint was filed by Michael Martin in his capacity as a Special Assistant Attorney General. Michael Martin is the law partner in the connected law firm of Dunn, Martin, and Miller. The final page of the complaint carries the required signatures of Jim Edgar as governor, Kirk Brown as the Secretary of IDOT, Roland Burris as Attorney General, and Michael Martin. These signatures of the governor and the Secretary of IDOT were false and constituted knowing acts of perjury and forgery by Michael Martin. The complaint was filed in 1991, well in advance of any environmental studies or public hearings required by the above-cited statute, 605 ILCS 4-510, or the requirements clearly provided for under Section 1.05-6 of IDOT's Policies and Procedures Manual. On August 16th of 1993, Governor Jim Edgar sent a letter to Robert Hickman, who was Edgar's appointment as Executive Director for the Tollway. The letter clearly authorizes the planning of the North-South Tollway and further states that the specific locations cannot be determined until after environmental impact studies. The actual official public hearing for the environmental studies was held over a year later, on November 16th of 1994. The letter to Director Bob Hickman was sent 2 years after Michael Martin of the connected law firm of Dunn, Martin, and Miller filed his condemnation complaint swearing that authorization for construction and the location of the project had already been approved. The signatures of Governor Edgar from his letter to the Tollway in 1993 and the condemnation complaint from 1991 do not match. This is because Michael Martin signed the governor's signature without approvals or authority. This was not only a case of perjury, but was also a case of forgery. On September 11th of 1990, I met with IDOT officials to discuss the advanced acquisition of my home. At this meeting, I was presented with the initiation of negotiation letter. This letter establishes my rights as a displaced person under federal law and also establishes my rights to relocation assistance and benefits. The initiation of the negotiation letter document was presented as evidence in a subsequent eviction proceeding filed against me by the Attorney General's office in 1992. At trial, the letter's provision of a comparable replacement dwelling with a purchase supplement of $7,900 was admitted to having been made in error because the replacement dwelling was not a comparable replacement dwelling, and that under the Federal Relocation Act, I was entitled to construct my replacement dwelling on property that I owned nearby, which I had acquired for that purpose. I was denied zoning to rebuild my replacement dwelling on my property by Will County because IDOT officials had appeared at the county board hearing and requested that the county restrict development in their right-of-way. My zoning application to rebuild my replacement dwelling was denied. It was also admitted at trial that my property was no longer in the right-of-way for the project and was not going to be needed. The letter itself further claimed that my property would not be needed for construction of the highway until March 30th of 1991. And this was several years before the required environmental studies and public hearing. The letter further states that I had a right to a review of claims by the director of the highways, and that I had a right to request the courts, state and/or federal, to address my grievances. I did file for my right to an administrative hearing for the denial of my relocation benefits, but in response to my request for a hearing, it was the Office of the Attorney General that filed the eviction proceeding against me and denied my right to the administrative hearings, as well as a denial of my rights to relocation assistance. This was all done as part of their pay-to-play corruption involving unlawful acquisitions of property before environmental studies and public hearings. My business was ruined by IDOT's actions because I had loans against my properties for development costs, and the failure to secure zoning for my property development in accordance with the published land use plans ruined the value of the collateral for my loans. I represented myself at trial, and I subpoenaed IDOT officials to appear and testify. Those officials admitted under oath, as a matter of record, that IDOT had violated several provisions of advanced property acquisitions, as well as dozens of provisions of relocation rights and benefits for my family and my business, including the provisions under state and federal law that prohibited evictions for the purpose of avoiding relocation benefits and assistance. However, the Assistant Attorney General, Kathy Twine, argued that the state's Forcible Entry and Detainer Act was a limited statutory proceeding unrelated to the issue of relocation assistance and benefits. The only issue to be decided was whether or not I withheld rent payments. I was ordered to stop all arguments pertaining to violations of acquisition and relocation laws under penalty of judicial sanctions. Kathy Twine was connected and bragged to me that she would receive a political appointment with David Orr's office after the conclusion of my trial. Shortly thereafter, she received another political appointment as head of the state's Judicial Inquiry Board. I appealed the circuit court's decision, and in my appeal I was represented pro bono by attorney Michael Freeman. The Attorney General's office, through Assistant Attorney General Brian Barov, lied to the appellate court, claiming that Illinois had never adopted the Administrative Review Act to review my relocation claims, and that I could not raise those claims in an eviction proceeding. The court rubber-stamped the Attorney General's false pleadings and further moved to strike all evidence and testimony regarding my rights as a displaced person, and further ruled that I was not a displaced person, contrary to the evidence and the clear language of the statutes defining a displaced person. I wrote a letter to Governor Jim Edgar detailing the frauds that occurred in court against me and the fraud of the acquisition of the hedge property. When the Tollway took over the litigation from IDOT, there had already been a determination of value as a matter of record for the property, but Michael Martin negotiated a settlement with the connected developer that was double the amount established in court. Governor Edgar and IDOT Secretary Kirk Brown responded by letter dated October 14, 1994, affirming my rights as a displaced person, and the governor initiated a special state police political corruption investigation into the hedge property acquisition. This letter by Kirk Brown as Secretary of IDOT clearly contradicts the complaint filed by Michael Martin for the hedge property by stating correctly that this project was only in the planning stage, and it further evidenced the corruption in the court's ruling that I was not a displaced person. Under the state's Administrative Review Act, jurisdiction to review relocation rights is vested with the agency and not the courts. The decision of the Secretary was a final legal determination of my rights and could not be challenged in the courts except under the provisions of the Administrative Review Act. I worked very closely with the agents of the Illinois State Police Division of Criminal Investigations concerning the Don Hedge property, also known as Bluff Oaks Estates. I worked closely with State Police Investigator Sergeant Edward T. Baker, County Deputy Sheriff Lynn Jenkins, and Will County State's Attorney James Glasgow. The search warrant filed in this investigation reads like an episode from The Sopranos. Some of the most important corrupt public officials in this investigation were Alfred Ronan, who was the registered lobbyist for the Empress Casino Group out of Las Vegas. Al Ronan had a long career in Illinois politics, including the Illinois Senate, and was a former member of the General Assembly's Transportation Committee. Roger Clark was a Tollway board member and the mayor of Bolingbrook. Philip Engstrom was Roger Clark's accountant and co-conspirator as agent for American Consulting Services, Inc., sharing the same office with Roger Clark. Also named in the search warrant was Frank Howard, who is the chief executive counsel for the Tollway under Roland Burris. Don Hedge and Continental officers, who were the co-owners of the property, which was also known as Bluff Oaks Estates, or BOE, as was named in the search warrant. There were several other entities associated with these conspirators, such as Alfred G. Ronan Limited, American Consulting Services Incorporated, Citizens for Clark, Continental Offices Limited. Their businesses and campaign funds are named on page 10 of the search warrant as having been engaged in the commission of bribery, official misconduct, and theft. Page 10 of the search warrant lists the probable causes as follows. The property had been purchased by Continental Offices Limited from the amount that was issued was $1,250,000. Other officials were also named in further acts of misconduct. Those officials were Attorney Michael Martin, Andrew Brick as the head of land acquisition for IDOT, Frank Howard, the chief executive counsel to the Tollway, Rob Douglas, an attorney working under Frank Howard and a member of the DuPage County Republican Central Committee, Robert Hickman, the executive director of the Tollway, Joseph Kotlars, the law partner of Frank Howard and former member of the General Assembly Transportation Committee, and Philip Engstrom, who is the agent for American Consulting Services, Inc. John Frederick, who was the head of acquisitions for IDOT, Kirk Brown, the secretary of IDOT, and Greg Bays, the former secretary of IDOT. Special agents of the Illinois State Police Division of Criminal Investigations witnessed Don Hedge after he was interviewed in his office in Naperville by the Illinois State Police and special agents of the Illinois State Police Division of Criminal Investigations conducted a surveillance of Hedge. And according to the special agents, Hedge left his office shortly after the interview and walked across the parking lot to the family restaurant, where he used a public telephone located inside the foyer of the restaurant. However, a special agent was able to overhear portions of Hedge's telephone conversation, and according to that special agent, Hedge stated on the phone that they're going to take it to the grand jury, and I just talked to my attorney during the interview. The Illinois State Police had just informed Hedge that the case was going to the grand jury. In a later interview, Hedge admitted that he used the public telephone to call Roger Clark or Alfred Ronan because he stated that Ronan would not accept his telephone calls unless they were made from a public telephone. This is a common tactic used by the mob when they fear that their telephones are being wiretapped, and they would always use a public phone or payphone. On page 23 of the official search warrant, it states that based upon the facts described above, your complainant believes that officials from IDOT and the tollway committed the offenses of bribery, official misconduct, and theft, and that they received a financial gain or a personal advantage for themselves or for others in exchange for their decisions to substitute plaintiffs in the condemnation suit and for their participation in settling the condemnation suit. Based upon the facts described above, your complainant believes that Alfred Ronan, Don Hedge, Continental Offices Limited, and Philip Angstrom are legally accountable for the criminal activity engaged in by IDOT and tollway officials. On page 12 of the search warrant, it mentions a case being prosecuted in DuPage County against Robert Hickman involving Joseph Kotlars, who is the law partner of Frank Howard. It was at this time that Pate Phillip and his brother Art Phillip arranged for the removal of Robert Hickman as Governor Edgar's appointee as director of the tollway. Robert Hickman came out and publicly opposed the need for construction of the proposed I-355 Tollway. When I wrote my letter to Governor Edgar regarding the fraud on the appellate court committed by Assistant Attorney General Brian Barov made a call to my attorney Michael Freeman in my presence, and he threatened Mike's law license with the ARDC if I continued writing letters seeking my rights. Mike withdrew as my attorney out of fear of losing his license and confided to me that I would never receive a fair hearing in an Illinois court. Mike was right, and I continued to represent myself until I met my dear friend Louis P. Yangus. Regarding the Hickman trial, this was a connected property acquisition deal with another mob-run business, Waste Management. The state's attorney of DuPage County essentially framed Robert Hickman for a land deal orchestrated by Pate Phillip with the cooperation of Roland Burris against his appointee, Frank Howard, who served as the executive counsel for the tollway, and his law partner, Joseph Kotlars. Another member of the Transportation Committee, Senator Dunn, a leading Democrat in Will County and later appointed as Judge Dunn of the connected law firm Dunn, Martin, and Miller, was best friends with Pate Phillip, the head of the Republican Party in DuPage County. They shared holidays together with their families. In the Supreme Court decision regarding the trial against Kotlars, Howard, and Hickman, the court went into great detail describing the chain of events and the people that were involved in this connected land deal. This process took place starting in July of 1991 and culminating in October of 1992. Attached are the campaign contributions for Roland Burris, showing 3 payments of $5,000 on July 23, 1992, coming from Joseph Kotlars, Heilengetter and Associates, and Frank Howard, coming from One Authority Drive, the official office of the Executive Council at the tollway headquarters. Howard was given immunity from prosecution for his testimony against Hickman. There are several other campaign donations moving back and forth from the Empress Casino, Alfred Ronan, Roland Burris, Waste Management, and Thomas Dunn. There was another major political player in the Don Hedge land acquisition controversy, and that was Senate Minority Leader Pate Phillip. Included are letters from Pate Phillip, the Minority Leader of the Illinois Senate, and letters from his good friend Clifford Carney involving Gregory Bays, who was the Secretary of IDOT at the time of the attached letters, dated in September of 1990. These letters detail the property of Don Hedge, who is listed in the letters as their mutual friend. These letters were not seen during the state police investigation of the Hedge property. I received this evidence under discovery in the federal environmental impact statement complaint, where I was the lead named plaintiff in this landmark environmental lawsuit. As is clearly evidenced by these letters, connected developers and powerful politicians were engaging in land speculations based upon advanced knowledge of highway interchange locations. The letters that were sent by Clifford Carney, the attorney that was representing Don Hedge, were sent to Gregory Bays and to Pate Phillips. And the letter that was sent to Pate Phillips stated, "I am enclosing herewith a copy of a letter that I have sent to Greg Bays at the Illinois Department of Transportation regarding some property currently owned by the Illinois Department of Transportation. Our mutual friend, Don Hedge, is developing a subdivision immediately to the west of this tract of land and would be interested in acquiring the 300-foot right-of-way from the Department of Transportation if it is true that they are planning to move their right-of-way further west. If you can be of any assistance in getting information for me relative to this so that I could follow through on it, I would appreciate it." But when we looked at the search warrant on page 19, the Illinois State Police were investigating and interviewing Kirk Brown, the Secretary of IDOT, and Kirk Brown admitted that Al Ronan contacted him on behalf of Hedge and suggested that the Tollway take over the acquisition of Bluff Oaks Estates. Brown admitted that Greg Bays, former Secretary of IDOT, also contacted him on Hedge's behalf regarding the Bluff Oaks Estates. In an interview with Bays by the Illinois State Police, Bays admitted having several conversations with Hedge regarding the Bluff Oaks Estates. He also admitted calling Brown on Hedge's behalf. However, when Hedge was asked by the state police about his conversations with Bays, Hedge responded, "Who the hell is he?" This was a clever cover-up, keeping Pate Phillip out of the investigation, because he was one of the most powerful politicians in the state of Illinois and the close personal friend of Judge Thomas Dunn of the connected law firm of Dunn, Martin, and Miller. When I shared the connection of Roland Burris with the Kotlars trial to the state police investigators, they wanted to expand the scope of their investigation. But Roland Burris ordered the state police to quash their investigation. I was told by the head of the state police that the Attorney General's office had their own agenda and there was nothing he could do. But he suggested that I contact the FBI, which I did. During this time, the Attorney General's office continued their malicious efforts to deny my relocation rights and evict me from my home. My efforts to fight them resulted in my friendship with Louis P. Angus. Lou was the longtime chairman of the Republican Party in Will County, as well as the longtime chairman of the Will County Board. Lou had served as director of Illinois financial institutions under Governor Ogilvie. However, as soon as he got into office, he had a crooked deal presented for his approval, and he would not go along with it. Ogilvy had deep mob connections, and in order to get this connected deal approved, he removed Lew as Director of Financial Institutions and promoted him to Chief Executive Counsel for the governor. And his replacement approved the connected deal. Lew and I hit it off because we were both fighting the same government corruption of organized crime. I'll go into the history and details of my personal connections to Cerrone, D'Arco, Giancana, and the mob, as well as the JFK assassinations in another corruption expose as part of the series. As for Ogilvy, he was publicly known for prosecuting Tony Accardo, but this was a pretense because the convictions were overturned on appeal, and as a result, double jeopardy applied, and Accardo could never ever be tried again for all of the crimes that he had committed. When the Attorney General's office continued to try to evict me after the Secretary of IDOT confirmed my status as a displaced person, my previous attorney, Michael Freeman, and Louis Yangus met with James Glasgow, the state's attorney for Will County, and because of a recent federal court ruling, it was decided that the eviction could not be enforced because of jurisdictional issues. Lew and I co-founded a grassroots environmental movement called the South Corridor Against the Tollway. We were then contacted by the Environmental Law and Policy Center. Lew had me act as president and spokesperson for our group, and I closely worked with the staff attorneys at ELPC and BPPI, the business professionals in the public interest. We eventually filed suit in federal court over environmental violations, and we won a landmark environmental ruling stopping the construction of I-355. I was the lead named plaintiff, establishing the class action status of the lawsuit. My efforts to expose the violation of relocation rights in numerous media outlets caught the attention of Michael Madigan, the Speaker of the House, and I appeared before the Joint Oversight Committee of the General Assembly. Based upon my testimony, the committee conducted public hearings concerning the violations of relocation rights by the Illinois State Toll Highway Authority on October 6th of 1997. Jeffrey Schoenberg was the chairman of the committee, and several dozen families appeared and testified at the public hearings to the horrors that they experienced by the tollway's evictions of families with 30-day notices of evictions without relocation benefits or assistance. I was ordered not to appear and to give further testimony at the public hearings. After the hearings, I was asked to provide my extensive research on relocation laws to a subcommittee for the purpose of drafting new legislation. An amendment was adopted and passed under the state's Toll Highway Authority Act in 1997 for the purpose of requiring relocation assistance and benefits in accordance with federal law. I was given credit by the staff attorneys at ELPC for the adoption of the amendment. This act of amending the law was a cover-up and a fraud upon the public, orchestrated by Michael Madigan and the corrupt Attorney General's office. Here is the proof of that cover-up and the fraud perpetrated for the purpose of securing federal project approvals and the avoidance of federal prosecutions for this massive fraud. On December 22, 1993, a letter was sent by Edward R. Gower in his capacity as Chief Counsel of the Illinois Department of Transportation. This letter was sent to Roland R. Moses, Esquire, who was the Regional Counsel of the Federal Highway Administration. This letter was also copied to Frank Howard, the Chief Counsel of the Tollway. The letter was also copied to Lyle Rentz, the Administrator for the Federal Highway Administration of the Illinois Division. In this letter, IDOT raises the issue of compliance with the federal Uniform Relocation and Real Property Acquisitions Policy Act. That's 42 U.S.C. Section 4601. The letter recognizes that this project had been planned by IDOT and the Federal Highway Administration based upon federal funding. IDOT was granted Federal Cooperating Agency status, allowing it to act on behalf of the Federal Highway Administration under federal law. This letter raises the concern with the tollway taking over the project and the requirements of the environmental hearing process, which required compliance with federal laws. The Federal Highway Administration required the tollway to become a federal cooperating agency, replacing IDOT as the lead federal cooperating agency. The letter explained that at a recent meeting between IDOT and the tollway, they requested that the draft environmental impact statement not address compliance with the Uniform Relocation Act. The tollway does not want to give the impression that it is bound to comply with these federal requirements. On February 10th of 1994, Ronald R. Moses, the Regional Counsel for the Federal Highway Administration, responded to the letter from IDOT's Chief Counsel, Edward R. Gower. That letter states as follows: in your correspondence of December 22nd, 1993, regarding the above matter, you ask whether the draft environmental impact statement must address compliance with applicable federal laws and regulations. I recognize there will be no federal funds in this project. However, the Federal Highway Administration is the lead agency in the preparation of the DEIS, and as such, the document must address and be in compliance with all federal laws and regulations. The public hearings held by the General Assembly's Oversight Committee regarding the blatant violations of relocation rights by the Tollway Authority were held in October of 1997. Nearly 3 years after the Tollway and the Attorney General's Office of Chief Counsel was advised of the assurances of compliance with relocation laws as a requirement for federal project approvals. Following is a copy of the official Tollway Relocation Benefits Program from 1997. These monetary benefits are approximately only 10% of the benefits required by federal laws and regulations, and there are no assurances for the provision of comparable replacement housing assistance prior to displacement. The tollway was clearly bound by the state's Displaced Person Relocation Act, 310 ILCS 40/4, and the Illinois Administrative Code, 92 Illinois Administrative Code 518. The conduct of the tollway was a violation of pre-existing state laws. The federal regulations regarding the Relocation Act's benefits and protections are found as Title 49 of the Code of Federal Regulations, Part 24, and under Part C, Section 24.206, this section explains the requirements for any eviction. I have highlighted the relevant sections, and they explain very clearly that any person who occupies the real property and is not in unlawful occupancy on the date of the initiation of negotiations is presumed to be entitled to relocation payments and other assistance set forth in this part, unless the agency determines the person received an eviction notice prior to the initiation of negotiations, and as a result of that notice is later evicted, or the eviction was not undertaken for the purpose of evading the obligation to make the payments and other assistance set forth in this part. For the purposes of determining eligibility for relocation payments, the date of displacement is the date the person moves, or if later, the date a comparable replacement dwelling is made available under Section 24.207. Section C, under advanced payments, states that if a person demonstrates the need for advanced relocation payments in order to avoid or reduce a hardship, the agency shall issue the payment. Under Section F, deductions for relocation payments, it states that an agency shall deduct the amount of any advanced relocation payment from the relocation payments to which a displaced person is otherwise entitled. Similarly, a federal agency shall and a state agency may deduct from any relocation payments any rent that the displaced person owes the agency, provided that no deduction shall be made if it would prevent the displaced person from obtaining a comparable replacement dwelling as required by Section 24.204. My rights as a displaced person and every other family displaced by I-355 have been violated. This fraud has been perpetrated by the corruption of the Attorney General's office and the courts through corrupt judges. Another great fraud by our corrupt officials is the pretense that no federal funds were generated for the construction of the tollways. This is going to blow your minds. Under the U.S. Code, Title 23, Section 160, Congress allocated to the state of Illinois, as reimbursement of the cost of the construction of the interstate by the tollway for the years 1996 and 1997, the sum of $2,533,000,000. This document lists the original cost incurred by the tollway to have been $475 million. Our tollways were fully paid for with an extra $2 billion. Where did the money go? The RICO statutes are very clear. Under 18 U.S. Code, Section 1962, Paragraph A, it shall be unlawful for any person who has received any income derived directly or indirectly from a pattern of racketeering activity or through collection of an unlawful debt in which such person has participated as a principal within the meaning of Section 2, Title 18 of the U.S. Code, to use or invest directly or indirectly any part of such income or the proceeds of such income in acquisition of any interest in or the establishment or operation of any enterprise which is engaged in or the activities of which affect interstate or foreign commerce. And the interstate highway system certainly qualifies for that. Under Section B, it's very clear. It shall be unlawful for any person through a pattern of racketeering activity or through collection of an unlawful debt to acquire or maintain directly or indirectly any interest in or control of any enterprise which is engaged in or the activities of which affect interstate or foreign commerce. It also states that it shall be unlawful for any person to conspire to violate any of the provisions relating to interstate commerce. And under 18 U.S. Code Section 1961, the definitions, racketeering, as used in this chapter, means any act or threat involving murder, kidnapping, gambling, arson, robbery, bribery, and extortion. And we already have evidence of bribery from the search warrant. It also states that any act indictable under any of the following provisions of Title 18 of the U.S. Code, including Section 201, which relates to bribery, Sections 1341 relating to mail fraud, Section 1343 relating to wire fraud, Section 1344 relating to financial institution fraud, Section 1503 relating to obstruction of justice, Section 1510 relating to the obstruction of criminal investigations, Section 1511 relating to the obstruction of state or local law enforcement, Section 1512 relating to tampering with a witness, victim, or an informant, Section 1513 relating to retaliating against a witness, victim, or an informant. And I think that we have satisfied all of those provisions under Civil RICO in this current investigation of the massive fraud and corruption involved with the construction of our interstate highway system. Make no mistake, this is the biggest corruption scandal in Illinois history. And there are a lot of important, influential, powerful, corrupt people in our government that belong in jail. And I urge for our state's attorneys and district attorneys to do their jobs and to start grand juries and to start criminal investigations. Thank you, one and all, and God bless America.